Thank you very much, Nicolas. It will be now my part to bring some flesh to the bones and show you what counsel in proceedings before the Regional Court of Mannheim are now arguing, which points are argued amongst the parties concerning the ECJ's decision Huawei in versus LCII, and how we think or thought about those points. First, I just want to briefly summarize the main aspects of the Huawei's decision so that everybody's on the boat, and then I will focus on 3 or 4 points of that. The ECJ ruled that Article 102 of the European Treaty demands certain obligations to be fulfilled by the proprietor of a SEP in order not to abuse its dominant position, because the rationale behind that is that it's not the patent itself which is so valuable, but it's rather its power rather stems from it being incorporated into an industry standard. And therefore, the ECJ ruled that the proprietor of such a standard essential patent has to fulfill certain steps where he seeks to get an injunction rendered by the court. The ECJ, however, pointed out very clearly that this rationale does not apply to a claimant who only claims for damages and the rendering of accounts, which means the past use. So what does the owner of a standard essential patent have to do? The ECJ says, first, prior to bringing that action, first point that I will discuss with you, he has to alert the alleged infringer of the infringement by designating the patent and specifying the way in which it has been infringed. I will be discussing with you, so what does this exactly mean? How do you have to alert or inform the infringer of the patent infringement? Then, if the infringer shows his willingness, his general willingness to take a license on friend terms, he also, prior to bringing an action, he has to make a written offer for a license agreement and specify the royalty and the way it is to be calculated. That's what the ECJ says. Where the alleged infringer then rejects that offer for the reason that, from his perspective, it's not friend, he will have to make promptly and in writing a counteroffer in accordance with recognized commercial practices in the field and good faith, and must not delay the further negotiations. That's what we got to decide upon. And you can imagine how the briefs look like. 150 pages of what has happened during the last 2 years, where the proceedings were stayed because we waited for the ECJ's decision. And you find like timelines which with the behavior of both sides, and each side wants to argue that the other side is the bad guy, and it was only him who wanted to postpone the proceedings, or and wants to convince us of that. In case the patent owner then again rejects that offer, the infringer will then have to render accounts and to provide appropriate security or deposit a sum sufficient to cover the past use. 4th point. I will now outline 4 points of major discussion amongst the parties. The first question was, is the regime of the Huawei versus LCII decision already applicable to cases where the claim was filed before the ECJ's decision had been rendered? So we all already decided upon that, and we do not think that it makes sense to hold the SEP owner to conditions set out in the ECJ's judgment for the first time where he did not know them before. Because in Germany, under German law, what did the SEP owner do? He wanted to follow the guideline of the Federal Supreme Court, the Orange Book decision, and after Orange Book rationale, it's up to the defendant, to the infringer, to make the first step. So why should he see himself in the position to be obliged to make the first step and make an offer? The other thing that we've been thinking about is, what would the SEP owner do if we would say, no, your claim is dismissed because you didn't follow this program before you filed the claim? the SAP owner could then, under German procedural law, just withdraw his claim, fulfill this requirement, and file the claim again a few months later after he fulfilled these steps. But then this would only be possible, the withdrawal of the claim, as long as that case had not yet been argued in front of the court, as the withdrawal of the case depends on the consent of the defendant. So it would be very arbitrary. We had cases where we didn't have an oral hearing. In this case, you could just withdraw the claim, file it again. In another event where we already argued on that case and then stayed the proceedings, the withdrawal would depend on the consent of the defendant. So to us, this doesn't make much sense, and therefore we think that for those cases, the SAP owner may still fulfill the requirements in the course of the proceedings. Of course, the infringement of the patent claimed is always set out in detail in the claim. And in all of our cases that we have to decide upon right now, we have offers that at least are claimed to be friend by the patent owners, because they made their offers during the time that we stayed the proceedings. So, so far we do not have a single case where the SAP owner did not make such a proposal to the defendant. Second question, what is sufficient to inform the allegedly infringing party of the patent infringement? So the parties discussed here whether the information has to be as substantiated as a claim under the German Code of Civil Procedure, meaning that the infringement has to be set out in such a detail that the court could render a judgment on default. The other perspective of the claimants is that it must at least be sufficient to inform the other side by the way of using claim charts. And another very interesting follow-up question is whether the claimant only has to give this sufficient information on the patent which is the basis of the claim, or where he seeks, like in most cases, a worldwide portfolio license of all licensed patents, or at least a significant number of patents. That's what the defendants argue. They say, okay, you have to set out each and every of your 2,000 patents like a substantiated claim under the civil code. We don't think that's true. And we think that claim charts are sufficient to inform the infringer. Moreover, we think that it's not even sufficient to alert the infringer by using such a claim chart, but maybe that it's still sufficient to summarize the technical field of the invention and just make reference to the parts of the standard without doing that in the detailed form of a claim chart. Because the rationale of the ECJ, we think, is that you have to alert the defendant, and therefore we think it's enough that he knows there's a patent, it's declared to be standard essential, this is the technical background of the invention, and you can find that incorporated in that and that part of the standard. That's it, and therefore then it's up to him to assess whether the patent is valid and whether it's incorporated and used by him. Okay. A highly debated question right now is, moreover, has the first offer of the patentee to the allegedly infringing party to be friend in the sense that it has to be determined in the proceedings whether the offer really was friend, or is it just sufficient that the offer was friend in the eyes of the claimant? That's very difficult. We think that if one would say that the friend offer of claimant has to be friend from an objective perspective, this would burden the infringement proceedings with a very complicated determination of what is friend. And we think that this was not the plan of the ECJ. So therefore, what we do is not saying if there's an offer, that's okay, then it's up to the defendant, but we scrutinize that offer and assess whether the claimant has convincing grounds for being of the for thinking that his offer is friend, and the claimants usually do that. In the cases that we see, they refer to licensing programs that they have and then set out why they think that those rates are not excessive, and point out that they have other licensees who were already willing to take such a license. And we think that this is enough for the defendant then, that we then can ask the defendant to make a counter offer and say, okay, I don't believe that this is, friend, what you do, but that's what my understanding of friend looks like. So it's rather a test of the willingness of the claimant on the one side to abide by its friend declaration, and of the infringer to take a license on the other side. Fourth point, when the ECJ says that upon rejection of the counteroffer by the claimant, the infringing party has to provide appropriate security. What sum will the deposit have to cover? Only the sales of products which allegedly fall under the claim patent in the country where the claim was filed? Or does he have to make a deposition for, or a deposit for the worldwide use? In our cases, most of the defendants did a counteroffer, but the counteroffer was nothing more than an orange book offer. So it was just limited and restricted to the claimed patent, and therefore they only argued therefore we only have to provide security for the use in our country, so here in Germany, and that's it, and we will deposit 5,000 euro, full stop. On the other hand side, it was clear that the group of companies that the defendant belonged to makes use of those patents in other, which are enforced in other jurisdictions, and both groups of companies are arguing and discussing and negotiating about worldwide portfolios. Therefore, to us, it doesn't make much sense to restrict that deposit just to the past use in the country and only for the patent claimed. That's just briefly what we've decided upon, and I'm very eager to learn what the rest of the panel will say to that approach. And I think, Miguel, it's your turn now to make comments on that from the Council's perspective.